Hello viewers, I am Professor Sharanjeet, working at the Rajiv Gandhi National University of Law, Punjab. Today we shall discuss fatal accidents liability under torts. Dear listeners, imagine a scenario where a car owner loses control of his vehicle and causes an accident, injuring and killing many people. In such cases, two things can happen. The law can take action against the person responsible for the accident, and the victims and dependents of the car crash can seek compensation for the losses arising due to such an accident. Such accidents are referred to as fatal accidents. Thus, we need to understand what the meaning of a fatal accident is. A fatal accident refers to an accident when a vehicle hits a person, an object, or another vehicle, causing injury or damage. In most cases, a fatal accident leads to the death of the victim. In simple words, we can say that a fatal accident is one that leads to the death of someone or very serious bodily injuries. During the olden times, when mobility was infrequent and there was no vehicular traffic, fatal accidents were very few. With the passage of time, advancements in science and technology led to steam engines, and consequently, the movement of people grew. Machinery for industrial operations also became much more advanced. Gradually, the wave of industrialization led to the migration of people to bigger cities and greater mobility by vehicles. All these changes also increased the likelihood of people suffering from fatal accidents. However, it was observed that the victims of accidents could not get the desired compensation due to lack of clarity about applicable statutes. This eventually led to the passing of special laws in our country to provide compensation and relief to the victims or next kith and kin of the people who died due to fatal accidents. Special laws have been passed from time to time, keeping in mind the compensatory jurisprudence with regards to fatal accidents in India. The most primitive legislation in this regard was the Fatal Accidents Act 1855. This colonial era legislation was modelled on the British Fatal Accidents Act 1846. The Fatal Accidents Act 1855 was an act to provide for compensation to families for loss occasioned by the death of a person caused by an actionable wrong. The preamble of this law provided that whereas no action or suit is now maintainable in any court against the person who, by his wrongful act, negligence, or default, may have caused the death of another person, it is oftentimes right and expedient that the wrongdoer in such a case should be answerable in damages for the injury so caused by him. Section 1A provided for suit for compensation to the family of a person for loss occasioned to it by his death by actionable wrong. This section said that whenever the death of a person shall be caused by a wrongful act, neglect, or default, and the act, neglect, or default is such as would, if death has not ensued, have entitled the party injured to maintain an action and recover damages in respect thereof, the party who would have been liable if death had not ensued shall be liable to an action or suit for damages, notwithstanding the death of the person injured, and although the death shall have been caused under such circumstances as amount in law to felony or other crime. Dear viewers, the Act further stated that every such action or suit shall be for the benefit of the wife, husband, parent and child, if any, of the person whose death shall have been so ensued, and shall be brought by and in the name of the executor, administrator or representative of the person deceased, and in every such action the court may give such damages as it may think proportionate to the loss resulting from such death to the parties respectively, for whom and for whose benefit such action shall be brought, and the amount so recovered, after deducting all costs and expenses, including the cost not recovered from the defendant, shall be divided amongst the before mentioned parties or any one of them in such shares as the court by its judgment or decree shall direct. Section 2 of this Act further states that not more than one suit or action shall be brought for and in respect of the same subject matter of the complaint. Section 3 further stated that the plaintiff in any such action or suit shall give full particulars of the person or persons for whom or on whose behalf such action or suit shall be brought, and of the nature of the claim in respect of which such damages shall be sought to be recovered. Dear viewers, now we shall discuss the Public Liability Insurance Act 1991. This important social welfare law also aims at providing immediate relief to persons who are affected by accidents occurring while handling hazardous substances or due to industrial hazards. This Act works on the principle of no fault liability by holding the owner of a hazardous substance or industry liable for death or injury caused to any person other than the workman or for damage caused to the property. In order to give relief and compensation to the victim of an industrial hazard, Section 4 of this Act requires that the owner take out insurance before he starts handling any hazardous work or dealing with hazardous substances, which he is also required to renew from time to time. As per the law, where the accident results from hazardous activity or operation, the person injured, his or her legal representatives in case of his death, or the person whose property is damaged shall file an application for relief with the collector of the district, who on receipt of such an application shall dispose of the claim for relief in a swift manner within 3 months of receiving such an application for relief. In the case of Madhya Pradesh State Electricity Board Jabalpur versus Collector Mandela, the Madhya Pradesh High Court held that electricity is a hazardous substance for the purpose of application of the Public Liability Insurance Act 1991. In this case, the Madhya Pradesh Electricity Board avoided the award of compensation by the Collector Mandela for the death caused by electrocution on the ground that electricity is not a hazardous substance as defined in the law. The court rejected the plea and held that electricity consists of electrons, which are substance. Therefore, electricity is a substance and the Electricity Board cannot ignore their liability under the Public Liability Insurance Act. Next, we shall discuss the Workmen Compensation Act of 1973. Dear viewers, The main objective of this law is to enable workers who become victims of accidents during the course of their employment to seek compensation from their employers. The main objective of this law was to provide relief to workers who come from poor and marginalized sections of the society and are not very educated. Section 3 of this law provides that where a workman sustains bodily injury, disablement, or dies due to accidents in the course of his employment, the employer shall be liable to pay damages to be paid as compensation to the workman, and in case of his death to his legal representatives. However, the accident must arise out of and in the course of employment for the applicability of the Workmen Compensation Act of 1923. In the case of Roshandeen versus Preeti Lal, the Supreme Court held that any agreement by a workman to the effect that in case of an accident arising out of and in the course of employment, he waives his right to claim compensation for the injury or disability caused to him would be void or voidable. The liability of the employers to pay compensation under Section 3 of the Act cannot be avoided, minimized, or curtailed by an agreement between the employer and the worker. In the present case, the employer fraudulently tried to escape liability to pay compensation by inducing the workers to enter into an agreement to that effect. The court directed the matter to be referred to the Commissioner of Compensation for determination of the quantum of compensation and ordered an award in favor of the workmen. Next important law with regards to fatal accidents is the Motor Vehicle Act 1988. It was in the year 1939 that the first Motor Vehicle Act was passed. The Act has been amended from time to time to make it responsive to the latest requirements and challenges. The Motor Vehicle Act is resorted to provide compensation in cases of fatal accidents. Sections 145 to 164D deal with the insurance of motor vehicles against third-party risks. Section 146 provides for the necessity of insurance against third-party risks. It says that no person shall use, except as a passenger, or cause or allow any other person to use a motor vehicle in a public place unless there is a policy of insurance in force in relation to the use of the vehicle by that person or that other person, as may be the case in this case. Provided further that in case of a vehicle carrying or meant to carry dangerous or hazardous goods, there shall also be a policy of insurance under the Public Liability Insurance Act of 1991. Section 149 deals with settlements by insurance companies and their procedures. It states that the insurance company shall, upon receiving information about the accident, either from the claimant or the accidental information report or otherwise, designate an officer to settle the claims relating to such accident. Section 150 provides for the duty of insurers to satisfy judgments and awards against persons insured with respect to third-party risks. Under this law, Section 159 places a duty on the police officer with regards to a fatal accident. It states that the police officer shall, during the investigation, prepare an accident information report to facilitate the settlement of the claim in such form and manner within 3 months, containing such particulars and submit the same to the claims tribunal and such other agency as may be prescribed. Section 161 of this Act deals with special provisions as to compensation in case of a hit and run motor vehicle accident. It states that notwithstanding anything contained in any other law for the time being in force or any instrument having the force of law, the central government shall provide for paying, in accordance with the provisions of this Act and the scheme made under subsection 3, compensation in respect of the death of or grievous injury to persons resulting from hit and run motor accidents. Subsection 2 states that, subject to the provisions of this Act and the scheme made under subsection 3, there shall be paid as compensation in respect of the death of any person resulting from a hit and run motor accident a fixed sum of 2 lakh rupees or such higher amount as may be prescribed by the central government. In respect of grievous hurt to any person resulting from a hit and run motor accident, a fixed sum of rupees 50,000 or such higher amount as may be prescribed by the central government. Section 162 deals with the scheme for golden hour. Notwithstanding anything contained in the General Insurance Companies Nationalization Act 1972 or any other law for the time being in force or any instrument having the force of law, the insurance companies for the time being carrying on general insurance business in India shall provide in accordance with the provisions of this Act and schemes made under this Act for treatment of road accident victims, including during the golden hour. The central government shall make a scheme for the cashless treatment of victims of accidents, and such a scheme may contain provisions for creating a fund for such treatment. Section 164 deals with the payment of compensation in cases of death or grievous injury. Section 164 provides for a scheme for interim relief for the claimants. Section 164B provides for the setting up of a motor vehicle accident fund by the central government. Furthermore, Section 165 deals with setting up or constituting a claims tribunal for the purpose of this Act. A state government may, by notification in the official gazette, constitute one or more motor accident claims tribunal for such areas as may be specified in the notification for the purposes of adjudicating upon claims for compensation in respect of accidents involving the death of or bodily injury to persons arising out of the use of motor vehicles, damage to any property or third party so arising or both. Dear viewers, Chapter 12, Sections 165 to 176 comprehensively deals with the constitution and working of the Claims Tribunal. Chapter 13, under Sections 177 to 210D, deals with the offences, penalties and procedures under this law. This chapter paves the way for creating criminal liability in the event of a fatal accident. By creating specific offences like driving at an unsafe speed, driving dangerously, driving by a drunken person, driving by a person who is mentally or physically unfit to drive, racing and trials of speed, using a vehicle in an unsafe condition, offences by companies, penalties for not wearing protective health care, failure to allow free passage to emergency vehicles, driving an uninsured vehicle, failure to comply with standards for road design, construction and maintenance, offences by juveniles and hit and run cases. Listeners, now we shall discuss award of compensation in case of a fatal accident. As discussed above, the Motor Vehicle Act specifically provides for the payment of compensation to the victim of a fatal accident or its dependents. The multiplier formula is applied in determining the quantum of compensation, but the compensation may vary from one person to another, and it is difficult to come up with a one-size-fits-all principle. For the purpose of the Act of 1988, the Supreme Court in the case of State of Haryana versus Jaspir Kaur explained, it has to be kept in view that the tribunal constituted under the Motor Vehicle Act is required to make an award determining the amount of compensation, which is to be in the real sense damages, which in turn appears to be just and reasonable. It has to be kept in mind that compensation for the loss of limbs or life can hardly be weighed on golden scales. The said provisions of law clearly indicate that compensation must be just and not to be a bonanza, not a source of profit, but the same should not be a pittance. Similarly, in the case of National Assurance Company Limited versus Indira Shrivastava, the court observed that the word just compensation should be assigned a broad meaning. A court of law having regard to the change in social conditions must consider the question not only with regard to the pay packet the employee carries home at the end of the month, but also other perks that are beneficial to the members of the entire family. The court has ruled that the amounts that were required to be paid to the deceased by the employer by way of perks should be included in computing his monthly income, as that would have been added to his monthly income by way of a contribution to the family. The court, however, said that from the said amount of income, the statutory amount of tax payable must be deducted. Assessment of the quantum of compensation. The Motor Vehicle Act helps in ensuring road safety and also in addressing compensation for accident victims for injuries, disabilities or fatalities arising from motor vehicle accidents. This law serves as a legal recourse for individuals and their families who have experienced harm due to the negligent or wrongful actions of motor vehicle owners or drivers. In the case of Sarla Verma versus Delhi Transport Corporation, the Supreme Court observed that having regard to the age of the deceased and period of active work life, the appropriate multiplier should be selected. The court stated that the claimants in a death claim for the purpose of compensation must establish the age of the deceased, the income of the deceased, and the number of dependents. Section 171 states that where any claims tribunal allows a claim for compensation, such court or tribunal may direct that in addition to the amount of compensation, simple interest shall be paid from such date not earlier than the date of making the claim, as it may specify on this behalf. Furthermore, Section 173 states that a person aggrieved by an order of a claim tribunal can prefer an appeal to the High Court. As discussed above, in the case of a fatal accident involving a person, the multiplier formula is used for calculating just compensation. But difficulty may arise where the victims of a fatal accident happens to be young children of tender age. As the children are not earning, how do you calculate their future income? The Supreme Court, with regards to fatal accidents involving children of tender age, held that in view of uncertainties, neither their income at the time of death nor the prospects of the future increase in their income nor chances of advancement of the career are capable of proper determination and estimation. The reason is that at such an early age, there are uncertainties with regards to their academic pursuits, achievements, careers, and subsequent advancements in life. So far as the award of compensation in the case of children is concerned, where the question cannot be decided on any legal principle, compensation may be granted on the basis of the notional income. In the end, I would like to say that today thousands of motor vehicles are in use across the length and breadth of the country, and the largest number of injuries and deaths are taking place on the roads on account of motor vehicle accidents. In view of the fast and constantly increasing volume of traffic, the victim or his legal representatives may be entitled to recover damages as per the principles of social justice in a speedy and hassle-free manner. With this, we come to the end of today's lecture. Thank you very much.